And we're good on my end whenever you're ready.
Okay, good morning. This is the August 17th session of the zoning hearing examiner docket. My name is Scott Heenan. I'm the zoning hearing examiner for the city of Cincinnati, and I will be presiding over this hearing. Case before us today is case number ZH20220114 involving 3860 Hyde Park Avenue. The purpose of this hearing is to allow applicants and opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any opposing party wishes to offer must be presented at this hearing. Hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. The public will then have an opportunity to speak after the applicant has presented its case. If there is more than one person opposing an application, those persons should decide amongst themselves the length of time each will have to speak. If an opposition group is in attendance, I may request that a spokesperson be chosen to speak on behalf of the group. The applicant is represented by an attorney. The applicant's attorney may cross-examine any person who has testified at the hearing. If a party of record is represented by an attorney, the attorney for the party of record may present any witnesses after the applicant has presented its case and may cross-examine any person who has testified at the hearing. In the event that any party testifies or offers argument in opposition to an application, the applicant should have an opportunity to rebut the testimony and/or argument offered in opposition. After the applicant has been given an opportunity to rebut any testimony and/or argument offered in opposition, any attorney for a party of record will have an opportunity to make a closing statement. Finally, the applicant will have an opportunity to make a closing statement. After all presentations have been made, I will close the hearing. Decisions may be expected generally within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make comments. I may also refuse to consider hearsay testimony or documents. That means any evidence you want to introduce that consists of the statement made by a person who is not present at this hearing or a document that includes a statement of a person who is not at the hearing. In the event of any technical difficulties with the video conferencing technology, I can continue or postpone this hearing at my discretion. Since we're doing this virtually, we obviously don't have a sign-in sheet showing that we have Weston Menzel from the planning examiner, and we have Pat Brinker on behalf of the applicant. This time I'll ask that anyone who plans to offer testimony be sworn in. If you intend on testifying, please take yourself off mute, raise your right hand, and answer out loud. Do you solemnly swear that the testimony you give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, with that, turn it over to the applicant.
Well, thanks for your time today, everyone. We're here today to discuss 3860 Hyde Park Avenue, and it's all right if I share my screen?
Sure.
And can everyone see a site plan and a photograph here?
Yeah.
Okay. I have the site plan here for 3860. It's a 2-story existing residence with the back portion of the house being built as a 1-story family room. We're here today to discuss the variance for a dimensional variance on the side yard of the home. 3860 is built similar to the rest of the homes on Hyde Park Avenue on the north side of the street. They all are situated with a reduced, or by today's zoning code, a non-conforming side yard with a larger side yard to their east that allows access to the individual detached garage on the back of the home. So with the existing first floor, the owner is proposing to tear off the roof and build a new owner's suite on the second floor. That owner's suite is comprised of a bedroom, a bathroom area, and a closet. And there's a plan available for that in our application. The easiest way and the most productive way maybe to build this would be to continue the existing side yard of the existing house. That allows for some structural ability to use this as an existing first floor as a bearing wall, versus if we're held to the required 7-foot side yard, we'd be looking at staggering the second floor wall over, let's call it just open space of the first floor, requiring a rather large structural beam that then impacts the existing kitchen, which is located in this area of the home as well. So with the second floor addition, we're not increasing or proposing to decrease this existing side yard of 4'1.5", 4'1" I think is the way the staff report noted it. So the addition then isn't encroaching any further or making it any worse an already non-conforming situation. And as we go back to maybe some of the other side yards on the street, we actually have one of the larger side streets where this is at 1'2", this one relatively close, 7 inches. 5'7" is a little larger than ours. And I think the other one's at like 1'4" plus or minus. So I don't think with granting this variance that we would be in any way taking away from the neighborhood or having a negative impact on the way the other homes are set up. As part of this application, we've also asked for relief from the required side yard for a deck off the back of the house. And we're asking for roughly about a 2'6" encroachment onto that. We are, I think, at 3 feet 4 inches on the proposed height of this, slightly above the 3 foot requirement that triggers that. I believe that triggers that requirement to meet that side yard versus allowing to encroach into that side yard. So we're barely above that height, and adding this deck also allows for somewhat reasonable space. This isn't an overly large deck in it by any means, but it does allow access then to the rear yard. So our two asks here are for relief from the side yard on the deck and for relief on the second floor addition. I will point out that the owners did receive signatures from abutting property owners and others in the neighborhood. And they voiced no objections to this, and also that the staff report noted and the recommendation was for approval of the variance. So I don't know that I have any more maybe to outline the project. If you guys had any questions for us today.
I don't. So do you have anything else that you wanted to add, or?
I don't know.
Okay. In that case, given the only person here is Weston, I'll turn it over to Weston.
Good morning. I don't really have much to add. I just would maybe highlight the findings that I wrote in the report about the proposals compatible with the neighborhood as the applicant mentioned, as far as the other side setbacks and the hardship of trying to follow the existing facade on the first floor creates structural challenges. Or I'm sorry, following the setback creates structural challenges, and it's easier to build on top of the existing facade, structurally. And the expansion is upwards, not to the side, not closer to the abutting home. So wrap it up with that. Thanks.
Okay, I'll go back to the applicant. You got anything you want to say, or you're on mute? I can see that you're shaking your head no, but
no, thank you.
Okay. All right. Well, then I'm going to go ahead and close this hearing out, and I should be able to get a decision to you quickly. Hopefully within 2 weeks. Almost certainly within 2 weeks. Shouldn't take long.
All right.
All right.
Thank you very much
Thank
for your
you all.
time.